My name is Jason Creasy, attorney for appellant Joe Riley Prichard. I would like to reserve 5 minutes, please.
5 minutes.
This is a divorce action. It's a little simpler than the last one that you heard as those appellate issues, but it does involve a couple of similar things. One is the division of property, and another one is allocation of whether or not one piece of property was separate property. As you just heard, the standard in this case, one of the things we look at as far as reversal, once the court makes the finding, is whether or not the result is erroneous based on assessment of the evidence, whether it reaches a decision that's illogical, or employs reason that causes an injustice to the complaining party. So in this issue, we're talking about a 16-year marriage. First issue is Mr. Prichard, his father inherited some property, family farm. The proof at trial specifically said that his father agreed that there's a house on that property. He carved it off. That's shown in the transcript at page 54, that because of some issues about having it approve a setback and sewer, they had to wait a little bit. The proof in the case was that Mr. Prichard was ready, willing, and able to purchase the property prior to being married. So when Mr. Prichard actually got married in August, it was December of that year before he was able to actually purchase the property. So he was married August 22nd, 2016, and then purchased the property, 2006, and purchased the property 15 weeks later in December of 2006. The proof in the case specifically showed that his father said he wrote a personal check. Mr. Prichard said he wrote a personal check. Mr. Prichard said he had the funds prior to marriage to purchase this property. Specifically asked, I believe it was page 182 of the transcript, asked Ms. Prichard, did she contribute any money to it? She didn't contribute any money to the purchase. She didn't know where the money came from. Furthermore, the proof in the case, I believe transcript page 85 talks about Mr. Prichard, during that 15 weeks of marriage, was making about $12 an hour. Well, if you look at $12 an hour times 15 weeks, and you look at a person living and having taxes, things matter, there's no way you come up with $45,000 of marital property. I understand income made during a marriage is marital property. There's no possible mathematical way that that amount of money, $45,000, was made during the marriage. The proof is it was a personal check he wrote from his checking account. He had the money prior to marriage. His father said he had the ability to buy it prior to marriage. It was just merely delayed because of some procedural issues with the city of New Bern. Chancellor Childress found that property, which at first is correct, property acquired during a marriage is presumed to be marital property. It can be rebutted. Statute specifically says that when you have separate property prior to marriage and you convert that into property still in your name, it remains separate property. There's absolutely no proof by Ms. Prichard at all that any marital funds were used to acquire this property that he had received from his father. So first, the chancellor found, without there being any proof at all from Ms. Prichard, that we didn't rebut the presumption. There's 2 witnesses testified as to the source of the money and that it was a personal check from Mr. Prichard and there was no loan acquired. So the first premise I have is at the actual house in which they lived at 844 Old New Bern Road, that property was a separate property of Mr. Prichard.
Did the court not find basically that that property had transmuted into marital property because the wife had contributed to the acquisition, preservation, appreciation of that property throughout the marriage?
Well, I'm not sure that's the way that the court stated it. What I think the court, well, at first the court actually just said it was never separate property. But if you have separate property and someone contributes to your separate property and they increase the appreciation, that doesn't transmute the entire amount. One of the things I see in Mr. Weekly's argument, he references some cases that specifically talk about someone taking a loan off, paying it off during the marriage. That's not what happened here. She said that she made some physical contributions. If you actually look in my proposal, I said if the first $45,000 was Mr. Prichard gave that to buy the property with his separate funds. If there was another, because the court found that the value of the property is $100,000, if you argued that she increased value and that extra $55,000 was marital property, then still Mr. Prichard should not lose his first $45,000 that he used separate property. He never titled it in her name. After that, after the court made that ruling, he then went on in making other evidentiary findings as to values. One of the things I would just note is he did, in purposes of the division of property, note that wife's checking account was $2,000, even though she specifically testified that the amount of her funds in the checking account was $6,800. So that was a $4,800 mistake that's clearly shown in the record.
Did the court not make some reasoning for that, based upon her holding certain funds that were not normally in her bank account or something of that nature, something that had been deposited in the nature of a refund or something of that nature?
He mentioned money that was given her for a stimulus check, but that still doesn't change the fact that that's the amount of money that she would have had in her account. And then when it comes down to division of marital property and we look at the different factors that are there, I know that division of property doesn't always have to be equal, to be equitable. The cases over time have specifically said that when you have a long-term marriage, that I believe it said in book out versus book out, it's presumed an equal division is an equitable division. It was also said in Smith versus Smith that a long-term marriage supports more of an essentially equal division of property. I filed a motion, I believe, to alter or amend in this matter. Chancellor Childress went back and found, once again, when I pointed out that he had awarded, even if you take into account what I believe his erroneous assessment about 844 Old Newbern Road, even if that was marital property, even though I make the assertion it wasn't, he awarded 60.2% of all of the property to her, 39.8% of the property, I put that on the addendum, page 19 of my brief. He made the determination that she gets 60.2% of the property, that Mr. Prichard gets 39.8% of the property. And he also, in the allocation of that, awarded zero debt to Ms. Prichard and $710,000 of debt to Mr. Prichard. And when we look through all of the different factors for purposes of division of marital property, one of the things that I would say is this is a long-term marriage. It's a 16-year marriage. Both of these individuals, the court found, had medical issues. Wife had rheumatoid arthritis. Mr. Prichard had leukemia. Obviously, wife has more of an education than husband does. She has a bachelor's degree. Her testimony was that she could work as a teacher's aide but could not work as a teacher, even though the school would have to comply with Americans with Disability Act. So we have her with a higher education. We have both of them having medical problems. We have Mr. Prichard had a good income. He used to work for Caterpillar. He was a high school graduate who worked his way up from high school. The proof was he didn't control the fact that Caterpillar's plant closed down, and he had to find a new source of employment. And the proof was that Mr. Prichard tried to start selling insurance at White & Associates. And if you're trying to sell insurance when COVID hits, it just didn't work. That's what the proof was. So when the court went and looked at the factors, it really strained to try to find any way to apply a logic or reasoning as to why Mr. Prichard, number one, didn't get credit for his $45,000 that he paid out of pocket from his personal separate funds that he owned prior to marriage. If it weren't for a procedural hiccup of having to have a mini plat for a survey and sewer compliance issues, he would have actually had it titled in his name prior to the marriage. But 15 weeks later, he still used separate funds to purchase the marital residence, which, by the way, the proof also shows is cut out in the middle of his family farm. So I think, number one, he should be awarded the house, and then I listed in Addendum 2 what would be a proper division of property. If the court just found the first $45,000 he paid from his separate property, which was from his bank account, was his, and said he owed her $27,500 and divided everything else the way that the court did, she would still be getting 51.5% of the marital property. Thank you.
Good afternoon, Your Honors. I'm Tommy Weekly. I represent the wife, Rhonda K. Prichard. Addressing the issues directly, we think that the outcome of this should be that the judge's decision is affirmed. The addendum that Mr. Creasy attached to his brief sets out the court's division of property, and we agree with that division. It is accurately set out. The things that seem to be most an issue are the marital home. Mr. Prichard, the proof is, purchased that home from his father in December of 2006 after the parties got married in August of 2006. He purchased it for $45,000. He retrieved the check for that, but it didn't present any proof at trial of how much money he had in his account prior to marriage. There was no proof there whatsoever.
Why
Also,
would that proof be important, counsel?
well, I think if he wanted to prove that it was his separate funds, he should have shown, well, I had $45,000 plus in my account prior to marrying in August of 2006. All he showed was I wrote a $45,000 check in December of 2006. Proof also indicated that he had other sidelines of ways that he produced income during the marriage. He was asked about that, and he said, well, I don't do that now in 2021 or when we had or 22 when we had the hearing. But he said earlier on, I repaired cars and I guess what we call flipping cars, made extra money from that. So he had extra sources of income that could have accounted for the $45,000 that he had when he paid his dad. And his dad testified that he didn't know where the money came from. I think I asked him, did he borrow the money? He said, all I know is he wrote me a check for $45,000. He said he had money. Well, he had money in December of 2006 when he paid his dad. We think the property was certainly properly categorized as marital property. It was acquired during the marriage by definition. Opposing counsel argues, well, yeah, but we think we've shown it was acquired with separate assets, so pull it back out of the marital category and put it in separate. And I have, I think, commented in my brief that separate property does not remain indelibly separate property. There is transmutation that can occur. And I think in this case, it appears to me the case law, number one factor is what was the intent of the parties. This was the only house they ever lived in for the 16 years of their marriage, these two spouses and their daughter. In addition to that, wife worked during the marriage. She contributed heavily to the party's income throughout, although husband, as he stayed at Caterpillar, made more and more money, and more often than not probably made double than what she did. She contributed as a homemaker. Court made that finding, was responsible for the interior of the home, responsible for the traditional wife responsibilities one might think of, like taking care of the house, taking care of the daughter, getting the daughter to appointments and this and that, and school and that kind of thing. So the court found that she had contributed throughout the marriage, and I think essentially transmutation had occurred, even if it was separate. I noticed, I didn't put it in my brief, but there was a concurrent opinion by Justice Cottrell in Fox v. Fox, 2006 case, where she commented on the fact that you can make the argument, well, if it's marital, then the burden's on the other party to try to prove that it's separate. Or if the facts clearly show well, it was bought during the marriage, but it was acquired by separate proceeds, then that shifts the burden back to the other party. Say, well, no, it really wasn't separate, it's marital. And she made I think, kind of a wise distinction of, well, it's just on a case-by-case basis. Let's look at the intent. Let's don't get into shifting burdens back and forth. The intent is really the paramount feature here. And the most important factor, we think, is the fact it was the only marital home that the parties ever lived in, and the wife definitely did contribute. Regarding the overall division of the property, yes, it came out about 60-40. Of course, the case law clearly says that equitable doesn't necessarily mean equal. That happens at times, and I think, of course, the court, there's 10, 12 factors, and 36-4121, court goes through and determining what's equitable, and I think clearly the proof presented that husband, historically, during the marriage, I think at the time we were getting divorced, he had been away from Caterpillar maybe a year, the plant closed, and he was making $100,000 plus at Caterpillar. And my client, at that time, had experienced rheumatoid arthritis, had hip replacement while the case was pending, and her ability to produce income is limited because of that. And she explained that even though she had worked at some better paying jobs in the past as a medical technologist, that she couldn't do that anymore. She lost the dexterity in her hands, and she just couldn't handle the physical requirements of working in a lab. And what she was doing as a special ed assistant at their daughter's school was about all she could handle. And even with the better medical tech jobs, I think the most proof shows she ever made was $45,000. So husband always made more money. So I think in looking at the factors, I think one of the important factors in the division the court looked at was Mr. Prichard had a history of being able to make good money. He had the ability of also acquiring income-producing assets. He had purchased with a partner a storage facility, mini storage facility, a couple of years before the divorce, and showed an ability to be able to borrow substantial sums. I think the court maybe found a value on that of around $250,000, and there was a debt, yes, against it. While the case was pending, Mr. Prichard, although he's working as an insurance agent during the pandemic, and I think testified the first year he started, he made nothing, and he made more the next year. And the time we got to court, income was improving, but still not great. But somehow he was able to go out and borrow money to buy a apartment complex of some $500,000. Yes, it had a debt against it too, but both of those big investment properties did have some equity in it, and those properties were awarded to Mr. Prichard. So I think he showed he's got the ability to recognize good investments out there and the ability to somehow borrow the money to come up with the money to buy those things, and that his ability to earn future property was definitely much better than Ms. Prichard's. So I think that was a big factor in the court's determination. So we don't see any abuse of discretion here, and I think that's a standard that this court had to find to undo Chancellor Childress's decision. We think that it was fair and it was equitable, even though it's uneven. And one of the factors, I know last case it got mentioned, well, did the court put a value on the separate property of the parties? And as I recall, Mr. Prichard's separate property valuation was $155,000, and my client's was $17,000. Similarly, other factors I'll mention right quickly. There was a mention about my client's bank account. Well, yeah, it was unusual that it was $6,800 at the day that she testified about it. She said it had been as low as $400. And during the course of the case, during the deposition, Mr. Prichard had basically kind of got shamed into giving her half of stimulus money he'd been getting while the case was pending. Plus, she got a child tax credit, and she got a tax refund, and that added $7,200 to her bank account, so it was artificially high at that particular point, but was not usually that high. Also, the proof showed that while the case was pending, Mr. Prichard had pulled out about $60,000 in teller checks, which the court found he did not give a credible explanation of what had happened to that money. He'd done that in about the 2 years before we got into the divorce status. Also, in the 4 years leading up to the divorce, the parties would receive joint income tax refund, which Mr. Prichard would get each year. The wife testified that totaled about $42,000 some odd dollars, and she got very, very little of that. After arguing with Mr. Prichard about that, might get $1,500 a year out of those 4 returns. So he got the lion's share of that. The court didn't give her any of that. Maybe thought that was water under the bridge. I don't know. But the teller checks that totaled about $60,000 were largely unaccounted for. The court made a finding more than once that Mr. Prichard's testimony was not credible. And I think that's important also in the court reaching the determination that it made. It just didn't believe Mr. Prichard, and it is in the findings more than once. So we felt like, of course, we've asked the court to affirm the decision, but $60,000 teller checks, $40,000 or so in refunds that husband clearly received leading up to the divorce should have been considered by the court. It wasn't. It didn't go into the computations, but all in all, we think there's no reversible error here. There's no abuse of discretion, and we'd ask the court to affirm the trial court's decision. Questions? Thank you.
Thank you.
As it would relate to these teller checks, actually, I dispute that that's what the record shows. The record shows some checks that have been made. Most of these checks were 4 to 6 years. I mean, you're talking about someone explaining how they spent money 4 to 6 years before a divorce action was filed. As Mr. Weekly stated about the checking account, her checking account was $8,015 and it made its way down to $6,800. So his statement about the amount of that is not accurate. You can look at page 170 of the transcript. I would reference just a couple of things. I had gotten a decision, I'm guessing maybe 6 weeks or so ago. This court found in Webb versus Webb that when individuals take money that's from separate property and they put it in, even into something that's titled as marital property, that it's equitable for the court to give you credit for the contribution. In that specific case, Mr. Webb had put $200 and something thousand into this house that they were doing, and she put about $30,000 in it. And the house only appraised for $171, and Chancellor Childress in that case did a pro rata distribution and says, this is the amount percentage of this marital property of the equity that you get based upon your percentage contributions to her. What I would say in that case, it was a jointly titled piece of property, and the chancellor found in that particular situation that each person gets their pro rata part out. This situation here, it's clear there was the intent to purchase the property, there was the availability to purchase the property. She specifically testified she didn't put any money in it, she didn't know where the money came from. He and his father said that he was ready, willing, able to do it. He bought the personal check. Interesting argument that Mr. Weekly makes about showing what you had in your checking account. I think the proof in the case showed you can't get bank statements more than 7 years ago. Wants us to prove something that's incapable of being proven. You don't have to do that. If the proof says, I did this, someone else says, I did this, I had this money, and she says, she knows she didn't give any money. She knows she didn't contribute any money to it. The other thing that I'm going to mention one case just because.
Let me ask you, they lived in this house for 16 years together?
Yes.
And as I understand it, the court took into consideration her contributions to maintaining the property and maintaining the house. Is that how this was determined?
No, the court, partially, the court said that he didn't think the first $45,000 that we had proven came from separate property. That was the first thing that he said. As far as whether or not there was contribution from her, I'm not disputing that. The point that I'm making is the first $45,000 he spent from separate property, he should get credit for that. If you say that she contributed to the appreciation in value, if it's appraised at 100 now, Mr. Prichard should at least get credit for his first $45,000 of separate property contribution.
I mean, is that, well, no, okay, thank you.
And the last thing that I would just say is, this court, back in 2014, took up a case called Metzinger versus Metzinger. It was another case that I argued. In that particular case, it was a question about whether or not personal injury funds were subject to division as marital property. And the question was how much of the funds were for loss of compensation. In that particular case, we showed how much a person was making, and that the amount that the judge awarded was mathematically impossible. And that's the same thing as in this particular case. A person can't make $12 an hour for 15 weeks and have $45,000 of marital property because obviously employment compensation is marital property. That's impossible in this case. And so the math doesn't lie, and the same thing in the Metzinger case, this court found that mathematically the determination that the chancellor made was impossible.
Was there proof in the record that your client had other sources of income besides his hourly wages?
Not during that time period. There was absolutely no proof in the record that during that 3.5-month period, he had other sources. There was questions about in the marriage later on, did he buy and sell some cars? There's absolutely nothing in the record that says between August of 2006 and December 2006, he had other sources of income. Thank you, Your Honor.
Thank you for your argument, gentlemen. Madam Clerk, you may adjourn court.
All rise.